requiring that nominating bodies that they nominate both a man and a woman in particular circumstances, and there would be a need then to ensure that there is gender balance.
We've already covered that anyway.
Yeah,
it's done. Sorry, Deputy Ferris.
Yes, I asked the Minister just in relation to, I think it's subsection D. It's in relation to the quorum. That if when at report stage you're considering maybe changing the number from 11 to 13, that quorum then would change from 7 to 9.
Yeah, if we change the numbers, the quorum would change. I don't want to go back into the debate about changing the numbers, because there was a balance in the original numbers of 11 as between the legal professions and the lay membership, and I think that was also part of the thinking. I know Deputy Collins was saying there should be an equality of membership, and the way we have it, there's one more lay member than there is representative, I suppose, of the legal professions. So one of the issues when you're talking about 13 is, does it unbalance between the representatives of the legal professions if we put in an extra 2? But quite clearly, in the context of deliberating on whether it should be 11 or 13, that is an issue for consideration. But the issue you raised clearly with regard to a quorum would be a relevant matter as well.
Right. Thank you, Minister.
All happy? Okay, I'll put the question then that the section 18, there's a new section there in South. Is that agreed?
Agreed.
Agreed. Section 19, in the name of the Minister, new section, Minister to move.
Amendment 19.
Amendment 19, sorry.
Amendment 19 is primarily a technical amendment for drafting clarity. It's a reproduction of Section 8, subsection 13 of the Bill that has been placed as a separate provision in this amendment. It is only significant insofar as it does not reproduce the criteria of bankruptcy and arrangements with creditors as disqualifying criteria for membership of the authority. These are proposed to be removed from the bill, as I feel they are no longer appropriate since the enactment of the Personal Insolvency Act 2012 and the establishment of the Insolvency Service of Ireland. We are in a new era where the stigma of bankruptcy has been superseded by new resolution frameworks, and I don't want to bring the old approach to these issues into the enactment of new legislation.
Okay. Is relevant to the question? Okay, that the new section be there in South. Is that agreed?
Agreed.
Agreed. Amendment number 20, in the name of the Minister. It's a new section. Minister to move.
I move, Chairman. The proposed Government Amendment number 20 is, as you say, a new section, a side note of which reads removal of member of authority. Can be described as another cornerstone of the independence-enhancing amendments being tabled today, that it seeks to replace Section 8, subsection 12 of the published bill with much more detailed provision, the intention of which is to address previously voiced concerns that the Government would have a free hand in the removal of members of the authority without fair process or external scrutiny. Again, as I would emphasise, something that was never intended to occur. Key aspects of the new section are the following: the requirement of an Oireachtas resolution confirming the Government's decision that a member of the authority ought to be removed for one or more of the reasons set out in subsection 2. The criteria for removal set out in subsection 2, which no longer includes the Bill's controversial original text that the, quote, removal appears to be necessary for the effective performance of the functions of the authority, but instead states that the person, quote, is otherwise unfit to hold the office or unable to discharge its functions. The right to reply of the person to be removed and their nominating body, the additional safeguard of an appeal to the High Court by the person concerned or their nominating body.
Okay. The question is that the new section there in South. Is that agreed?
Agreed.
Agreed. Now, amendment number 21 in the name of Deputy Collins, Deputy McGrath. This is a new section. Acceptance of this amendment involves the deletion of section 9 of the bill, 21, 22, 25 to 28, inclusive or related, 29 to 35, inclusive or alternative, 21, 22, 25, and 25 to 35, inclusive, will be discussed together. So it's 21, 22, and 25 to 35 will be discussed together. Deputy Collins to move.
Thanks, Chair. Just give me the numbers again. Sorry.
21, 22, and 25 to 35. 21 and 22, 25 to 35, inclusive, to be discussed together. It's a total grouping of those amendments.
25.
Third grouping in a list there.
Okay, I suppose to summarise it, maybe just get the Minister's take on it. Really, I suppose what we're trying to get at in the series of amendments is to give the authority the degree of independence and to try and unharness it as much as possible from the political process. And I know we're in the same section that the Minister has referred to. Can I just get your views first, Minister, on what we're proposing?
Minister.
Well, Chairman, in relation to opposition amendments 21, 22, 25, 26, 27, 28 and 35, I'm opposed to these amendments. These amendments are proposals which have previously been considered as they were included in the Bar Council's March 2012 submission. In essence, the amendments seek to provide for oversight of the legal professions rather than direct regulation of the legal professions. They're essentially designed to bring us back to the legislation relating to the legal ombudsman. In essence, the amendments seek to provide, as I said, for oversight of the legal professions rather than direct regulation of the professions, which is the specific objective of the legislation and is central to this legislation. These amendments run counter to government policy as expressed in the bill and its provisions for independent regulation of the legal professions. The opposition amendments also fundamentally alter the functions of the authority while echoing others. It should be remembered that the Programme for Government of National Recovery 2011-2016 undertakes to, and I quote, establish independent regulation of the legal profession to improve access and competition, make legal costs more transparent and ensure adequate procedures for addressing consumer complaints. These are shared commitments under the EU-IMF Programme of Financial Support for Ireland, aimed at removing restrictions to trade and competition relating to the legal profession and legal costs, namely, to establish an independent regulator for the legal profession and implement the recommendations of the legal cost working groups, and to implement the outstanding Competition Authority recommendations to reduce legal costs. The bill therefore provides for the independent regulation of the legal professions rather than the supervised self-regulation model that the Bar Council is anchored to and which the opposition deputies would seem to prefer, notwithstanding the much higher confidence of the public in independent regulation. This is precisely why an early decision was taken by the government not to implement the Legal Services Ombudsman Act 2009, which was built upon the wrong model of supervised self-regulation. The point of departure from the policy perspective of this government is therefore independent regulation, not supervised self-regulation. At this point, I'd like to reiterate the continued urgency in relation to the advancement of this bill. The updated Memorandum of Understanding on Specific Economic Policy Conditionality for Ireland of the 3rd of June 2013 includes a specific undertaking under the title of Legal Services Reform that once the relevant legislation has been enacted, the authorities will take the appropriate measures to establish the Legal Services Regulatory Authority in an expedited fashion. The action is to be completed by the end of the fourth quarter of 2013 for the 13th review under the Troika programme. The June 2013 staff report of the European Commission was critical in the delay enactment of the bill and gave its opinion that legal services costs have, for the most part, failed to adjust during the economic crisis, and that legal services, and I quote, remain sheltered from competition and a drag on the economy's overall competitiveness. The recent Troika mission to Dublin has again emphasised the need to realise the modernisation and reform measures contained in the bill and the early establishment on an open for business basis of the new regulatory authority. The amendments tabled by the Deputy run entirely counter to that. The proposed Government Amendment number 29 to Section 9, subsection 2A is intended to allow the authority to make recommendations to the Minister following its review of the issues listed in that section, rather than leave them gathering dust on a shelf. Matters such as the admission requirements of the legal professional bodies and the availability and quality of education and training opportunities, etc., will not be directly under the remit of the authority, but will be monitored and any action that may need to be taken to address any concerns of the authority can be flagged by it. In relation to Opposition Amendment number 30, I am opposing this amendment, keeping under review the admission requirements of the Law Society relating to the solicitor's profession and that of the Bar Council relating to the barrister's profession are important functions of the authority. I do not intend deleting them. Otherwise, we will be accused of having no measurement of any nature of the state of the legal professions in real time to inform the authority's regulatory functions. Government Amendment number 31, proposed here in relation to section 9(2)(a)(2), is in response to a concern about the original drafting formulation, which was voiced to me by the heads of the law schools and specifically UCC Faculty of Law, which provided the proposed drafting solution. They were concerned that the provision might result in the authority overstepping the mark between it and aspects of both academic freedom and quality assurance that are enshrined in the Universities Act of 1997. There was also some concern that universities were singled out for mention when there are many other types of education institutions providing legal qualifications. I am happy to support the amendment as it both allays their concerns, does not detract from the authority's foreseen reviewing, in a very general sense, of the availability and quality of legal education. It is not intended to duplicate the existing academic standards regime with universities or other colleges concerned. Government Amendment number 32 is a minor technical amendment to correct a typographical error. Proposed Government Amendments number 33 and 34 are minor amendments designed to make the authority's monitoring function a little more meaningful by allowing the authority to make recommendations to the Minister. And I draw to the Deputy's attention the importance of the full independence of the manner of operation of the regulatory authority, and there not simply being an oversight body as to how the professions do these matters themselves. And if the Deputy needed confirmation of this, the Deputy might note that the insolvency regulations published in relation to personal insolvency practitioners detailed the various professionals who might perform that role, as well as others, and detailed the eligibility criteria, the need, the audit oversight mechanisms, and issues surrounding indemnity insurance. And amongst those included as individuals who can operate as personal insolvency practitioners, whose function in practical terms between debtors and creditors, whatever differences exist between Deputy Collins and myself and Deputy McLaughlin and myself on the bill, I think we'll agree on this one, that their function is essentially to mediate between the debtors and the creditors to see can there be a debt settlement resolution. Included within the group who can perform those functions in the regulations as published are both solicitors and barristers. I was somewhat surprised to note it was reported in one of our Sunday papers that the Bar Council might intend to block barristers from performing that function, which I think is contrary to competition and is not in the public interest. And if ever we needed an indication that there's need for an independent regulatory authority to be confirmed, it was readily confirmed in recent days. We must ensure there's proper competition in these areas, and in fairness to members of the legal profession, be they solicitors or barristers, that they have the facility to use their skill sets through different business models to the constrained and limited restrictive business models that currently exist.
Okay. Deputy Collins, you want to come back in?
Just a comment, Chairman, thanks. Minister, I don't know, were you saying it or were you quoting from a Troika report? I can't exactly recall when you were reading out that legal fees represent a significant drag on the economy and on competitiveness. I just want to say, put on record from my part, and I'm sure others will share this, that nobody in the legal profession is recession-proof, least of all barristers and solicitors. And we all have a lot of experience of legal practices in terms of the impact that the recession has had on them, in terms of the closures of some of them and the significant downsizing of others with resultant job losses. So I think we need to keep in our deliberations a sense of proportionality in relation to this, because what often gets reported is some very high-end, high-profile stuff,